sure that your opponents will accept and agree that. From what, as I understand it, we've got no evidence of any jurisdiction being agreed at all, and so there's no jurisdiction that anyone's objected to. But just if we go back to your first point about the node being in the DIFC, can you help me with this? As I understand it, Clevity, it's not a company that's based in the DIFC. It's got hundreds of nodes all over the world. And the one in the DIFC is no different to any of the others. So does this mean that if it's got a node in France, it could go to the French courts, and if it's got a node in England, it could go to the English courts, and if it's got a node in Peru, it could go to the Peruvian courts?
Your Excellency, for us to know whether the node is relevant to give the DIFC court jurisdiction, we have to know the rationale for citing a node within the jurisdiction of the DIFC. One of the rationale for a node to be located within the jurisdiction of the DIFC court is to enable all transactions coming from such locations to be concluded using that particular node.
But if it, what I'm asking you is, if there are nodes all over the world, if you're right that because there's a node in the DIFC, it's partially concluded here, but does that not also mean it was partially concluded in all these other countries as well?
Okay.
Is that right?
You are correct, Your Excellency. However, the DIFC, the practice in DIFC is that once there is no court that is exercising jurisdiction, and this particular position is the case in the case of Al-Qurafi and Bank Sarasin, that if another court is not exercising jurisdiction, or if another court has denies itself or it has rejected jurisdiction, and the case or the matter is before the DIFC court, the DIFC court will have jurisdiction.
So as I say, I understand your second point, which is that there's no other court that's been asked to take jurisdiction, but that's just because all that's happened is your clients issued proceedings in the DIFC, and then the appellant has challenged jurisdiction. But let me ask you this. We don't know, do we, whether this node in the DIFC was even switched on, functioning? We don't know whether this transaction passed through the DIFC node or not. We know that there is a node of Clevity that exists that's on a server in the DIFC, but it could be that it was switched off that day, for all we know. Does that not present a problem for you? I'm guessing by your smile that it might be.
Yes, that is a problem. However, it's room for ambiguity, it's room for other things to be, but we cannot just be making conclusions that the node was switched off. As much as we can assume it's switched off, it can as well be switched on. So it can as well be this way and the other way. So because of the fact that this is before this court and parties have properly instituted this case before the DIFC court, we can only argue that node, there is no evidence absolutely that the node was switched off. So we cannot conclude that the node was switched off. However,
so I agree with you. We can't conclude it was switched off. And sorry, I'm going to turn my camera off because I know we're getting interference again here, and that might make it better. I know we can't conclude it switched off, but the question I'm asking you is, do we think that maybe the lower court were a bit too quick to conclude that they knew whether it was on or not?
Your Excellency,
we'd feel pretty silly, wouldn't we, if we went and got some evidence tomorrow and they said, oh yes, the cleaners came and they plugged in the vacuum cleaner and they unplugged the computer and the computer was left off for a week before we realized. But it could be this transaction had no connection to us in the DIFC at all, couldn't it? Don't we think the lower court were a bit quick to conclude that this node had any relevance?
Your Excellency, if that should be the case, I believe the test for this should be whether if this case should be decided in any other court, the court would have reached a different conclusion. However, if that cannot be established, and if this court can reach a decision and another court will still reach the same decision, I believe it will not affect the substance of this case. So whichever court is exercising jurisdiction, as long as the same decision will be reached, I believe that is the most important factor that will be given consideration to.
Okay, well, that was all the questions I had for you. And was there anything else you wanted to add to your submissions, or shall I move on to the next speaker?
I would like to round off my submission, Your Excellency.
Okay, I'll just give you a minute or two to do that, and then we'll press on.
Okay. In rounding off my submission, I would like to put some comments in regards to the submission that was made by the appellant himself. He emphasized so much on the place of residence of the parties to this suit. However, looking at Article 5A1B, the article did not mention that parties must be resident within of the DIFC. What the particular aspect emphasis on is that the said contract must be concluded either or part within the duration of the DIFC. And I have established before this court that the contract was concluded within the platform. In fact, paragraph 6 of the Document of Fact, the document clearly states that the contract was concluded within the Clarity platform. And Clarity platform within the DIFC. Therefore, giving this court jurisdiction over this matter, and there is no clause that gives another court jurisdiction that the DIFC court will say, probably we don't have jurisdiction over this matter. So this court, ordinarily relying on the authority of losing and land, this court has a default jurisdiction over this matter. Naturally, this matter is proper before this court. And it is my final prayer before this court that this appeal should be dismissed as lacking merit, and a declaration should be made by this court that the trial court, the CFI, Court of First Instance, was actually right when it exercised jurisdiction over this matter. Thank you, Excellency.
Okay, thank you very much. Shama, it's obviously you've got the opportunity to rebut if you want to. I know we've had great difficulties with your connection. You're welcome to your rebuttal time if you want, or if you don't want to, I'll move on to Leila.
Should I start, Your Honor, or?
Yes, please do. Yep.
Is it possible to keep my camera off, because I haven't been hearing you properly for like 5 minutes, so it's really lagging. Okay.
Leila, thank you very much for telling me that.
Yeah.
If you have any difficulties hearing, I can see you put it in the chat at 5:20 a few minutes ago. I did notice that the University of Benin were having difficulty hearing in the last couple of minutes or so. If you at any point can't hear me, yes, please type it in the chat. And if I can't hear you, I'm going to type it in the chat as well, okay?
Okay, perfect. Okay.
Please go ahead. Thank you.
Yes, Your Honor, and may it please the court, I'll be going over the second ground on why there isn't any relevant mistake. Now, Your Honor, the Court of First Instance erred in concluding that the disputed trait was a result of an error based on Article 37(1)(a) of the DIFC contract law. It held that it did not have to examine the state of mind of the programmer when designing the program, and that it was sufficient that a reasonable trader would not have concluded the disputed trait. With that being said, Your Honor, the Court of First Instance disregarded the second cumulative condition stated in Article 37(1)(a) and failed to prove that the appellant caused the mistake or knew or ought to have known of the mistake. Also, Your Honor, for the programmer to have willingly intended to cause a mistake, he should have been able to or ought to be able to foresee all the possible outcomes of the interactions between Beta's algorithm and the other programs on the Clarity platform, which is impossible. Also, Setting an inflated price as a result of a low offering on the platform is not illegal by itself, because it aligns with the law of offer and demand. Furthermore, based on Article 37(2)(b) of the DIFC contract law and its explanations in Unidroit principles of international commercial contracts under Article 3.5, it states that even if there would be a relevant mistake, a party may not avoid the contract if the mistake relates to a matter in regards to which the risk of mistake was assumed, or having regard to the circumstances should be borne by the mistaken party. Now, Your Honor, by just being users on the platform, both parties have automatically accepted to trade based on automated trading. And through autonomous trading, it holds a risky nature because it does not involve any human intervention or any human interactions. Also, the respondent claims that she has entered into the trade under mistaken beliefs that the rate at which they were entering into the trade presented or did not deviate from the true market price. However, this is not a mistake as to the terms of the trading contract, but instead was a mistaken assumption as to the circumstances under which the trading contract would be concluded. And for the relevant mistake to void the contract or to be able to void the contract, it must be about the term of the contract specifically, and not merely be a mistaken assumption about the circumstances under which the contract was or would be concluded. So for the reasons I just gave, Your Honor, the Court of First Instance erred in dismissing the appellant's claim. There is no relevant mistake because the state of mind of the programmer could not have caused or prove that he ought to have known of a probable mistake and that the mistake did not occur on the term of the trade.
Okay, can I just, that's extremely helpful, thank you. Can I just ask you, if we look at Article 37 that deals with relevant mistake, and
yes,
we look at subsection 2, and I think you've addressed me already, I think, on
Article
Part B.
37(2)(b), yeah.
Yeah, where you're saying, well, look, if you're trading autonomously with an algorithm and you're using a computer, then you're assuming the risk that things might go wrong. But if we have a look at 2A, is there anything that you want to say to me about that? A party may not avoid the contract if it was grossly negligent in committing the mistake.
Your Honor, we can't really apply this article because when we're talking about automated trading, I mean, it's the programs by itself. I mean, the trade happens without any human intervention. So it's just the programs by itself. It happens automatically. So we can't really say it was negligence because also, and referring to the facts.
Well, I'll tell you why I'm asking. You've said that when we look at Article 37(1)(a), that we should be thinking not of the party making the mistake. You said that we shouldn't be thinking of the machine that was doing the trade, but we should be thinking of the programmer who programmed the algorithm. So what I'm asking you is, if we look at now 2A, do we need to think about whether the programmer was negligent in the way that they programmed the computer?
It isn't really a sense of negligence because, I mean, not every programmer's program is going to satisfy the other parties or the other user's program. So
I should say, I'm not trying to attack your case. I think I'm helping it, aren't I? If a party can't avoid the contract, if the other side have not programmed the algorithm to take account of this sort of situation, do you see what I'm driving at?
not really.
Well, I'm just saying that it could be argued, couldn't it, that the person who programmed the algorithm, if they didn't think to put parameters into it to say, well, if there's a glitch, if the price suddenly shoots up by a lot, don't do the trade. If they didn't put any kind of safety mechanism in, arguably they were negligent. And if they were negligent, then under Article 37(2)(a), they can't avoid the contract, can they? So I'm not attacking you. I'm just saying that theoretically there might be another line of argument for you there.
Yeah, exactly. And it's because it's the nature of the trade, of trading through cryptocurrency or through this type of platform.
Okay. All right. And so what about the fact that the parties were asleep? Does that make any difference to anything?
Not really, no, because I mean the programs run the trade, concluded the trade by themselves. So even if they were awake, they wouldn't even be able to press the accept or decline button.
I see that. All right. Well, thank you very much. That's extremely helpful. Can we move on now to the next speaker, which is going to be the junior respondent, please?
May it please the court? Am I audible? Your Excellency, yes, can you hear me?
Yes, I can hear you perfectly. Thank you.
All right. Good afternoon, Your Excellency. Ensuring appearance is P. Usiosefe. It spells U-S-I-O-S-E-F-E. I use with the initial P. And counsel is basing an argument on ground 2 of the issue at hand. It states that did the first instance court err in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37, sub 1A of the DIFC contract law, that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. On this issue, Your Excellency, counsel will be basing her argument on 2 standpoints. The first is that the contract can be said to be void based on the provision of Article 37, sub 1A of the contract law. And second, that the Clevity normal operating condition was at the time of the transaction non-existent. Your Excellency, for the purpose of conversing on this standpoint, counsel will be relying on the following authorities. They are Article 37, sub 1A of the contract law, Article 3.5 of Unidred Principles, the judicial authorities of Bell and Lever Brothers, the case of Koturi and Hasty, and the case of
I'm so sorry.
Your Excellency, yes, Your Excellency.
No, it's all right. You just faded out for a moment, but I think we can hear you again now.
Oh, should I take what I said again, Your Excellency?
No, I think I got it all. You were talking about, you just referring me, I've got your skeleton as well. You were going through, I think, paragraphs 15 to 17 of your skeleton, weren't you? Bell and Lever Brothers.
Yes, Your Excellency. And the citation of the judicial authorities mentioned are provided in the bundle. Now, proceeding to the substance of my argument. The substance of my argument, the first is the provision of Article 37, sub 1A of the contract law. Counsel would like to read the provisions of this article.
Yeah,
it provides that a party may only avoid the contract for mistake if, when the contract was concluded, the mistake was of such importance that the reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known. And A, the other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. Your Excellency, the major point or the import of this article is that the first is, would a reasonable man in the position of the party, in this case the respondent, would he have concluded with the contract being aware of the true state of things at the time the transaction was made? Accompanying that is, if the other party had made a mistake, or the other party was also mistaken, or he knew or ought to have known of the mistake. and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. Your Excellency, counsel is asserting that the elements stipulated by Article 37 sub 1A of the contract law is present in this case. Before the application of the facts provided in the Moot case with this statutory authority, counsel would like to mention the case of Houston and Hazel. Your Excellency, in that case, there was an agreement as to pension funding, and the plaintiff in that case was supposed to be the beneficiary of the fund. However, there was an error as to the calculation of the amount due to him. It was stated in the document that what was due to him was about 40.
So I think maybe
Hello?
Nikhil, I think you've got your microphone on. Let's see if I can.
Sugandha, can you mute Nikhil?
There appears to be an interference.
Just hold on a moment. We've got someone who's got their microphone on. I'm going to see if we can mute them.
Sugandha?
Sorry,
Yes, Vishnu, I've told Nikhil.
Thank you.
All right, thank you very much, Excellency. As counsel was asserting, in this case, the case mentioned Hassan and Hazel, the plaintiffs enforced the mistake of about $40,000 US, but proof was provided by the defendant in that case that what was actually due to him was $26,000 US, and the earlier document purporting to give him $40,000 US was made as a result of mistake in calculations. Your Excellency, the court held that the fact that there was a mistake in the calculations in that particular case was sufficient ground for the contract to be voided. Not only on that, but the fact that there was also a document which has been given to the plaintiff, which showed the breakdown of the calculations and total the actual sum of 26,000 in the document. So the argument of the defendant was that the plaintiff had the opportunity to know that there was actually a mistake when he saw the difference in both documents. Your Excellency, in this case, counsel is asserting that both parties were mistaken, and a reasonable man in the position of the respondent, who is also the claimant, would not have concluded the transaction. Now, in relating into the facts, counsel would like to refer to paragraph 456 of the statement of facts. Your Excellency, in paragraph 4, it was stated that Ms. Raz's program, which is Alpha, was programmed to purchase Yapol at the best price available on the Clevity platform. But from paragraph 5, we can see that a fundamental error occurred due to the upgrade, an error that affected the functioning of the system and caused a fundamental malfunction, leading to the exclusion of persons who were legitimately entitled to transact on the platform, with the exception of two persons who are the parties to this case. Your Excellency, the algorithm of the respondent ended up buying from the beta algorithm, but it was at the only available price on the platform at the time. This error, counsel would like to draw the distinction between best available price and only available price. Your Excellency, the word best generally is a superlative of the word good. It comes in the context of comparisons. But in this case, the algorithm, due to the error on the platform, couldn't make any comparison as to what was the best available price, due to the fact that persons who were legitimately entitled to be a platform as offerers or even purchasers were excluded from the platform at that time. Thus, it ended up buying at the only price and couldn't make the distinction due to this error. Secondly, Your Excellency, the algorithm of the defendant, who is the appellant in this case, which is beta, was programmed to sell Yapol at a highly inflated price when no other users offering to sell Yapol on the Clevity platform existed at the material time. Your Excellency, going back to the error, the counsel is asserting that there was a mistake on the fact that persons at the time, the fact that there were no offerers at the time was not because persons had made a choice not to offer, but because of the error which excluded persons from transacting on the Clevity platform. This can be traced to the mistake on the Clevity platform. So both algorithms were mistaken as to the true state of things. Of course, the Raz's algorithm assumed that was the best available price, whereas there was no room for comparison. Beta also assumed that Your Excellency, you want to say something?
Yes, I was going to ask you. I just want to understand what you're saying the mistake was, because as I understand it, your client wanted to buy at the best available price.
Yes, Your Excellency.
And at the time of this trade, the price she bought at was the best available price, wasn't it?
That is the distinction I'm trying to draw, Your Excellency.
So, I understand your point. You're saying, well, best is a superlative, so it means it can't be the only price. So
yes, Your Excellency.
Let's just help me with this.
Right,
if there was another trader on there, and let's say that they had a program, alpha, beta, let's say they called it gamma. And let's say the gamma program was very similar to beta, and it was programmed to sell, but instead of inflating the price by 250 times, it inflated it by 500 times. Okay, so let's say that during this glitch, there were two traders, there were three people on the platform. There was your client with alpha. There was Mr. Payne with beta, who was selling it offering it for sale at 250 times the price normally. And we had the gamma, we had someone with a gamma algorithm offering at 500. Under those circumstances, well, then you've got the best price, haven't you? You've got it at 250 instead of 500 times the normal price.
Of course, there would be a choice, but for the fact that there was no choice and it was due to the error, counsel is asserting that the mistake was due to the error caused by the upgrade in the Clevity platform. The basic fact that the algorithm had no choice in this particular case, it could not have bought at the best available price. Rather, it resulted in buying at the only available price, contrary to the programming. Thus, a mistake was made on the part of the algorithm of Mrs. Rani, who is a respondent as well as a claimant in this case. Can I proceed to the second point of?
Well, I just want help me with this. Obviously, I understand what you're saying is that your client now, having realized that there was a glitch while she was asleep, no criticism, didn't want to do the deal. But why should Mr. Payne have to give her money back?
Your Excellency, Mr. Payne, knowing that the transactions arose from fundamental malfunctioning of the system, would be acting under unfair commercial practice to insist that such errors should be enforced, knowing fully well that if the parties had a reasonable man as provided under the intro to Article 37 sub 1A, would not have continued, knowing fundamentally well that a malfunction had occurred on the system.
Just pausing there, you say that Mr. Payne knew. As I understand it, just like your client, Mr. Payne was asleep and had a computer doing it all for him. So presumably, just like your client.
I was referring to his insistence because you asked about the enforcement of the transaction. So his enforcement came after the transaction had been completed, meaning he now knew about what had happened on the platform. And to be unfair of him to insist that such error should be enforced, knowing fully well that it occurred as a result of a fundamental malfunctioning of the system.
But suppose he had the money that your client paid him, he might have committed that money elsewhere now. He might have an obligation somewhere else. Is he not entitled to some sort of certainty that the trade's been concluded? That's the end of it. He can move on to the next trade?
Your Excellency, in as much as it would be good, of course, to consider the position of the appellant, but it's also necessary to consider the position of the respondent. How about her losing and spending a whopping 250 times over the actual market price? Your Excellency, if the appellant was even in the respondent's shoes, I'm sure he would have instituted this action. So it is best for the purpose of commercial practice, best for the purpose of technological advancement, certainty in transactions, that where a fundamental error such as this occurs, then parties should be willing to do the right thing, which is void the contract on ground of mistake.
Okay, all right. Well, I'm so sorry. I'm conscious I interrupted you. You wanted to tell me the rest of your submissions, didn't you?
Of course, Your Excellency. Proceeding, counsel would, or was already saying actually that there has been a mistake. Then the introduction of Article 37 sub 1A says, would a reasonable man having knowledge of the state of affairs have continued or concluded this transaction? Counsel has already asserted that a reasonable man, no person of common sense, would want to continue a transaction that had occurred based on a fundamental malfunctioning of the system, where the respondent in this case had no choice but mistakenly bought at 250 times over the actual market price. Your Excellency, it is audible to the blind, it's audible to the deaf and visible to the blind, but no reasonable man would have continued this transaction knowing of the error. Thus, all the elements in Article 37, which are the elements necessary for avoiding a mistake, exist in this particular case. Therefore, the trial court was not in error in voiding the mistake. On the second standpoint, Your Excellency, counsel is asserting that the fact that the normal condition of the clarity system at the time of a material transaction was non-existent. And counsel is basing this standpoint on the case of Bell and Lever Brothers and Couturier and Hasty. In Bell and Lever Brothers, it was held that when the subject matter of a contract is no longer in existence as at the time of the contract, then the contract can be void for mistake. In Couturier and Hasty, what happened in that case was that there was a transaction for a cargo of corn. Now, when the cargo of corn was on transit from the Mediterranean to England, it perished and was disposed along the way. Unfortunately, parties continued in the transaction unaware of the position or the state of things as it were. But the plaintiff, who was the seller, wanted to enforce payment, saying that title had already been transferred to the defendant, thus he was to bear the cost. But the court said that at the point of the transaction, the subject matter had been disposed of, it had perished, was no longer existent, and thus the contract could be void for mistake. In the application of these judicial authorities to the case, Your Excellency, counsel is asserting that the foundation of this dispute, the foundation of the trade, that is a clarity platform. The normal functioning condition of the platform.
Just help me. In the Couturier and Hasty case,
yes, Your Excellency,
the corn was non-existent, but there's no suggestion here that the YAPL was non-existent, is there?
Your Excellency, counsel is asserting that the cryptocurrencies cannot be separated for the functioning of the platform. The platform is crucial and material to the trade. Without the platform, no trade would have occurred. And the fact that the platform was not in a normal working condition, then these cases apply because the situation at hand was the purpose.
But forgive me, wasn't the problem here not so much with the platform, but with your client's algorithm? Because you just programmed it to buy at the best available price because she assumed that she would always want to buy at the best available price. But of course, she hadn't thought that there might be circumstances where even though the price was the best available, she wouldn't want to make the trade. Isn't the problem that she just didn't think of that?
Your Excellency, it's the error that occurred on the platform cannot be separated from what resulted from the error, which is this disputed trade. And counsel is asserting that the fact that there was an error on the platform, the fact that it was no longer functioning as it ought to, then the subject matter of the transaction was non-existent. Counsel would not argue that it was just solely based on the YAPL, the cryptocurrency transaction, because the transaction cannot be separated from the platform. As a result, as a matter of fact, rather, if the error had not occurred on the platform, then counsel would probably not be here today arguing. So the transaction must be combined with the error on the platform. And the fact that the platform was no longer functioning as it ought to, then the subject matter was non-existent at the time, and this contract can be void for mistake.
Okay. All right. Was there anything else that you had left on your submissions, or?
None, Your Excellency. Counsel would like to submit and give her prayers.
Okay. Well, thank you very much. I've got your prayers on your skeleton. Don't worry.
Oh, All right, Your Excellency. Thank you very much.
Much. All right, so I think the only thing left to do then is we just move back to the junior for a rebuttal if she'd like to.
Yes, Your Honor, I would like to rebuttal the unreasonable claims made by the opposing counsel on my client, and specifically the point about setting an inflated price. Now, as I've said before, setting an inflated price is not illegal by itself. And since my client designed his program so that if there is one other user on the platform, the price automatically raises by itself. I mean, this aligns with the laws of offer and demand, because the price automatically increases. So it is not illegal by itself, and it's just the way that the programmer programmed it. So
Okay.
that's it. Thank you.
Thank you very much. Well, look, everyone, I know that this round has taken so much longer than was scheduled. And I just wanted to say thank you so much for sticking with it and for all your hard work. I've obviously listened really carefully to all your submissions. All I can say, and I sort of said it half as a joke, but it's also true, you know, this sort of thing can happen in real life when you're doing it in court for real. And, you know, all I can say is that when it does happen, the thing to do is, first of all, check whether people can hear you and tell them somehow if you can't hear them, whether it's sending an email, phoning them, whatever. I think in the real world, as I think I was saying earlier, if this was happening on a hearing, it would have just been adjourned by now. It's just because it's part of a competition here that we obviously couldn't do that. And so also we're very grateful for the tech people who tried to sort it out. Because I've been so busy making notes and things, I haven't had a chance to compose my thoughts about giving you guys some feedback. What I might do is see if I can send an email through Delvin a little later with a few sort of feedback thoughts, if that's all right. I can see that she's in the meeting. But I'm just conscious you guys have probably spent far longer on this round than was scheduled. So I think you probably all deserve a break. So just to say thank you very much on behalf of the organisers, and I wish you all the best of luck. All right, thank you very much.
Thank you,
Thank you
Excellency.
so
Thank you, Your Honor.
Thank you.
Bye.
Thank you. I was going to say, Delvin, should we go into one of the breakout rooms and I'll just have a chat? I'm conscious this probably messed up your schedule a bit.
No problem. Yeah, let's try. Let's see how I'm gonna get into the breakout room.
Or if you want, do you want me to just I can just email you a Zoom link and we can just have a regular Zoom if that's quicker.
Yeah, sure.
Yeah,
Let's do
I'll
that.
do that. No problem. Okay.
Perfect. Thank you.